So if you're about to write an offer to purchase a property in the state of Maryland, this is the document that is going to dictate most of the terms, your residential contract of sale. For the purposes of this particular video, please make sure that you are using the most updated version of this document. You can always check the bottom of any page. Here we are referring to the copyright 2024 version that was updated in October. So if you see 10/24, this video is talking about that one, but always check the MAR database to make sure you are working from the most updated version. So just going through this process, you put your date of offer. We emphasize that time is of the essence and all deadlines matter when it comes to any written agreement, especially a contract to purchase real estate. Put the names of the buyer and the seller. You're going to put the property address, indicate the county or city, and make sure you put in the zip code as well. The first kind of question you're going to have to confirm is whether or not the property is conveyed in fee simple. So you would check the box here, or if it is subject to ground rent. Ground rent is a pretty complicated and confusing topic, but basically, oftentimes this exists in Baltimore City. There are certain properties where the homeowner there needs to pay some additional sum of money to someone who owns what they call ground rent. So it's an interest in the ground. So that's just an extra fee that any particular owner is going to have to pay. So that will be in the land record somewhere, and it has to be disclosed on the MLS and by a seller disclosure. So make sure if you're a buyer and a buyer agent, you check the MLS and confirm, is it subject to ground rent or being conveyed in fee simple? Okay. Now here's the big one, purchase price. You're going to set forth the offer for purchase in dollars. You type out the dollar amount here and you write it out using letters here. So it's, say it's $200,000. You'd write 200,000 down here and you'd spell it out up here. For payment terms, this is where it gets into the earnest money deposit that is going to be held in escrow. So you always check the buyer either has delivered or will deliver within some certain date, a certain amount of money in escrow. So for the purposes of this example, let's say they haven't yet deposited yet, so they will deliver within 7 days of contract acceptance. Let's say it's 1% of the purchase price. So if it's a $200,000 property, they're going to make it a $2,000 earnest money deposit. What I always put here is just either by check or ACH would be a transfer from bank to bank. There are certain electronic methods to submit your earnest money, but essentially this is the buyer putting down a good faith deposit, which basically says this is going to be held in an escrow account, and in the event that the buyer breaches the contract and has to back out, that money is potentially forfeited to the seller, or at least it's money that can be tied up and fought over. So you always want to have a earnest money deposit set up in 8A. 8B would be if there's some additional deposit you wanted to put forward, say a non-refundable deposit or some other more aggressive term. Often this is blank, but this would be the opportunity to go ahead and add an additional deposit if that was contemplated. You also want to make sure you say who is holding the deposit. If it is going to be the buyer agent's brokerage, if it's going to be a title company, here's where you set forth where that is going to be held. And here, there's really helpful language here in bold for you. If it's being held by a brokerage, there's nothing else you have to do. If it's being held by a title company, then parties shall execute a separate written escrow agreement that sets forth the terms of how those funds can be treated and dispersed. I always encourage people to check that it's going in a non-interest bearing account. That is going to be the situation 99% of the time. You have to have a date of settlement, make sure that your buyers are available that day, and make sure it is a date that works with the seller before you fill this out. And then paragraph 11 is just a long checklist of all the available standard addenda that may or may not apply. right? So I always encourage buyer agents at the time of contract writing, just go through this list and make sure that you have everything you need. And just to make this be a reminder that, oh shoot, they do have solar panels, for instance. I need to make sure I add that addendum, right? So this is just a final checklist. So make sure you check all of the different addenda that apply. Okay. As we head down into section 2, we get into payment of the purchase price. So the first question is, what sort of financing is the buyer using, if any, and is there a contingency involved? Maybe the most common ones are going to be either conventional financing, FHA or VA, or maybe the ones I see most often. But please note that if there is a different loan product, it may have its own addendum that you need to include. So you're usually only doing one of these. For the purposes of today, we'll say they're using conventional financing, so you would check the box for the conventional financing addendum. If the buyer is seeking to waive their financing contingency, they could say no final contingency or no financing contingency, or they could say cash in this other file. Okay. Then there are really important deadlines associated with this financing application and commitment. And you want these to be relatively aggressive, just to demonstrate to the seller that you're acting in good faith. So let's say you are applying for financing within 3 days, and you are making sure you get a written financing commitment within 21 days. Something like that. Just work with your lender, make sure that they can meet these deadlines. Because as we said, time is of the essence, and making sure that you comply with all these deadlines and not accidentally fall into default with your buyer. To that end, I'll mention paragraph 21, where it is the buyer's responsibility to pursue this financing in good faith, make sure the numbers are all accurate, and make sure that they're not committing fraud or otherwise working in bad faith to try to get out of the deal. And I'll also mention that sometimes financing changes. You guys, maybe you were pre-qualified with conventional financing, but later decided it makes more financial sense to do FHA or something else. That is fine pursuant to this paragraph 23, so long as it doesn't harm the seller, right? If it's going to require additional inspections, or if it's going to require more time or an extension past the settlement date or extra fees, these are things the seller might object to and force you into your original financing option. So just make sure you communicate all of that really clearly with your buyer. Okay, as far as condition and inspections, paragraph 25 is pretty important, you guys. Just so we understand what is actually being contracted for and sold, seller shall deliver possession of the property vacant, clear of trash and debris, room clean, and in substantially the same condition as existed on the date of contract acceptance. So if a tree falls on the house in the middle of the contract, it is no longer in the same condition as it was at the date of contract acceptance, right? So this really provides pretty important protections for the buyer. And even if, there are the words as is somewhere in the contract, that doesn't necessarily void paragraph 25. So it has to be vacant, it has to be clean, and it has to be in substantially the same condition. Okay. If you are making it subject to an inspection, you need to check, have the buyer initial here, and you need to make sure that you include an addendum to this contract. So in addition to initialing here, you also need to make sure you include the property inspections addendum. Okay, working our way through, there's certain things the buyers will have to initial with regards to testing well water. If there is a well, they'll initial here. If they're waiving it, they'll initial here. If there is no well to test, they can just initial in the second part for buyer waives. If there's for agriculturally assessed property and also the Forest Conservation Management Program, these are things that the seller actually has to disclose. But if they fail to for whatever reason and it pops up later, if I'm the buyer, I always like to see the words seller, if any. So again, this just says if an agricultural assessment pops up, who's going to pay any associated fees? The seller. Same thing for conservation. Seller's going to pay if any of these should arise. Okay. There are a series of places where a buyer needs to initial related to lead-based paint. Lead-based paint is extremely dangerous. So it's something that there are really important disclosures, especially if a property was built prior to 1978. So you just have to go through and make sure that you understand the risks involved and that if there's any work that needs to be done later on an older property, that you may need to use a special contractor, but always refer back to materials provided by the EPA if you have additional questions. But the buyer is going to initial that they understand the law, initial that they understand that there are certain implications as it relates to renovations and repairs. And also they'll have to initial indicating that if the property was ever rented, it would have had to have been a part of the Maryland Lead Poisoning Prevention Program. Okay. There are a series of basically warnings and disclosures at the bottom, which were essentially mandated by statute in the state of Maryland. So make sure you go through these in the event that your buyer has any questions. As it relates to transfer of title and closing, there will be questions related to transfer charges. So specific, we're talking about recordation taxes, and then we're also talking about state and local transfer taxes. Okay, so in general, the assumption is that these taxes and fees are divided equally between the buyer and the seller. Okay, so for both of these cases, whether you're a first-time home buyer or not, it says all of these fees will be divided equally between buyer and seller unless otherwise stated here. So actually, if your intention is to split it evenly down the middle between buyer and seller, just leave A and B completely blank. You're only going to put something here unless you're deviating from that standard. So say the buyer wants to pay everything, they want to make a really aggressive offer, they can put in here buyer to pay all, right? So this is often left blank. If it's intended to be split equally, you would only write something here in the event that you are trying to create some different distribution. Okay. We're most of the way through, you guys. The last bit's just making sure that everybody signs. Date of contract acceptance is going to be really important, guys. This is the date which triggers all of your different timelines related to inspections, related to financing, and anything else. So you guys need to agree what this date is, and you need to make sure it's put down. The instructions provided here, we insert the date on which all final initials and signatures of all parties have been affixed to the contract. So say it's sent back and forth a couple of times. The last person that puts on the last signature and initial, they are going to go ahead and just type in date of contract acceptance, and that is the date upon which everything is going to be started, okay? So make sure, guys, by the way, once you have an executed contract, send it to the other side immediately, send your clients a copy immediately. That way you're complying with all of your ethical and fiduciary obligations. Oh, and by the way, if your buyer is a first-time home buyer, make sure you check this box so that they get all of their rebates at the time of settlement. And then finally, guys, your broker will thank you if you really fully complete buyer and seller names and mailing addresses, along with all of the brokerage information for both the buyer side and the listing side. So that is the Maryland Residential Contract of Sale as it was last revised in October of 2024. I hope that this was helpful. Thank you so much.